Hello, I'm Michael Healy, and I'd like to comment on another controversy that's currently rocking the Catholic Church. You see, currently I am a law student at Ave Maria School of Law in Naples, Florida. I also have degrees in history, philosophy, and theology. And I've been noticing lately that some of what I've been studying here at Ave Maria School of Law may be relevant to give, I think, a useful perspective on the debate that Pope Francis has caused the last few years about whether divorced and remarried Catholics can receive communion. Specifically, to put it in terms of Anglo-American law, the question is whether a divorced and remarried person's fittingness to receive communion should be judged by a bright line rule or a totality of the circumstances test. But before I explain that, I'm going to take a step back. A bright line rule is just what it sounds like. It is a clear-cut decision, a line drawn in the sand, that you're on either one side or the other. If you're on one side of the line, you fall afoul of the law. If you're on the other side, you don't. Every legal system has bright line rules, and they are very useful. They have their place. They're very clear-cut. They give you clear guidance. You know exactly where you stand. You know exactly where the person whose case you're examining stands. And for that reason, a lot of people like bright line rules. Bright line rules are also good because in a sudden, unexpected situation, it still applies exactly the same way as it always did. And you don't have to think on your feet. When you have a bright line rule, you can say, oh, he's speeding, pull him over, for example. I mean, there is in practice some gray area with speeding, so maybe it's not the best example. But if someone's 15 miles over the speed limit, then it's a bright line rule. You know for sure, pull them over. Now, there is a problem with bright line rules, though. And to illustrate it, let me just remind you of the case from 2001, Atwater versus City of Lago Vista. In this case, a police officer in Texas pulled a woman over and arrested her for not wearing her seatbelt. And to all of us, that seems a little crazy at first, but the Supreme Court said it was okay. Even though the Constitution says that people will not be subjected to unreasonable searches and seizures, the Supreme Court of the United States said it was okay for this police officer to arrest the woman for not wearing her seatbelt. Why? Because there was a bright line rule that allowed him to do this. The Supreme Court said because there was a law that allowed him to arrest somebody for not wearing a seatbelt, he had probable cause. And a warrant is not needed for an arrest, just reasonable, innocent, probable cause. Because there was an ordinance permitting it, there was reasonableness. Because he saw that she wasn't wearing her seatbelt, there was probable cause. And so he was able to do it. But most people would say this is a crazy result. Why should someone go to jail for a minor offense, like not wearing a seatbelt? So that can be the problem with bright line rules. They're sometimes not flexible enough to meet the demands of everyday life. Because no lawgiver can foresee everything in advance. And a bright line rule kind of expects you to do that. but it can't. On the other hand, a totality of the circumstances test is also what it sounds like. You take all of the different facts of the situation that seem to be relevant, and you say, all right, in light of all these facts, what's the best decision? Like, in light of all these facts, the police didn't allow him to have his attorney. They did not allow him to speak to any friends or family. They interrogated him for hours on end. They lied to him and said his friend would lose his job if he didn't confess to the crime. Totality of the circumstances, his confession was coerced and therefore should not be used in court. This is a different case that I don't remember the name of at the moment, but it illustrates the point. So that's the difference between a bright line rule and a totality of the circumstances test. So, how does this apply to a current debate in the Catholic Church? Well, traditionally, for many centuries now, the Church has had a bright line rule to determine if a married person can receive communion, or divorced and remarried, I should say. And the rule is, if you got an annulment, and which declares that your first marriage was not valid before you remarried, or if after remarrying you got the annulment and then got your second marriage recognized by the church, then you can receive communion. And then there's a few other minor exceptions known as the Petrine privilege and the Pauline privilege that I have never really studied in any depth and probably couldn't explain very well, but they also exist. But they're minor, rare exceptions, like if you've been kidnapped and sold into slavery and you have no idea whether your spouse is still alive, you can marry someone else. Things like that. And of course, with that particular exception to the rule, there'd be the assumption that you'll never find out if your previous spouse is still alive, because you'll never be able to go home again because you're still in slavery, or you're too poor to buy a ticket to get home again, or something like that. Anyway, so there's been a bright line rule. Either your previous marriage has been annulled, or your previous spouse died. There's that too. Either your previous spouse died, or your previous marriage has been annulled, or you can't receive communion. If you're remarried and your previous spouse is alive, you cannot receive communion. Bright line rule. Easy to understand, easy to apply. But, again, like I say, there's a problem with bright line rules, and that's that they can't always cover all of the circumstances of life. Just to be very plain and straightforward about it, it seems to me that it's quite possible for someone's previous marriage to be invalid, but for that person to lack the evidence to prove that it was invalid. It seems to me that would be a very real possibility that could happen. I don't know of anyone that this has happened to. It just seems to me that it could very well happen in very many cases, because not everybody keeps good records. And I suppose you would need to keep fairly good records to be able to prove that your previous marriage was not valid. So if there could be that there's many people who should get an annulment but can't, because they can't prove that there was an impediment that prevented the first marriage from being a valid marriage. And those people with the bright line rule would slip through the cracks. They would be unable to remarry within the church and would be unable to receive communion if they did remarry, despite the fact that they probably should have been able to remarry and still receive communion. And perhaps other situations could exist that would fall on the wrong side of the bright line rule, even though the person is probably innocent. This is just something I wonder in the back of my mind, but if you have a situation where one spouse was never faithful to the other at any time in the marriage, it makes me wonder if the spouse that was never faithful was never mature enough to have a valid marriage. But I could be wrong about that. This is just my opinion. Don't quote me on it. It's just something I wonder in the back of my mind. So what Pope Francis is saying, essentially, is that he has seen cases where the bright line rule seemed to have the wrong result. Marriage cases where someone maybe who should have gotten an annulment didn't. He's seen cases like that, he thinks. And so he does not think that the bright line rule is still appropriate. He wants a totality of the circumstances test to determine whether someone who is divorced and remarried can receive communion. It seems to me that that's essentially what this debate in the church is about. So, those are my thoughts on the matter. My minor contribution. Have a good day, everyone.